For several months now, work has been going on quietly on finalizing government's position on the report of the Constitution Review Committee. Over the last few weeks, government has been meeting to take this firm position. That position has crystallized and has been put together. So today, we are honored to have the presence of the the Attorney General and Minister for Justice, Dr. Dominic Ayine, to brief us on the position of government on the report of the Constitution Review Committee. Before he does that, though, only this morning, news filtered in about the ruling of the appeals court in the Sedinam case. So his office has issued a statement on the way forward. He will speak briefly to that before delving into the Constitution Review Committee's report. So without taking any more of your time, I would invite the Honorable Attorney General to the microphone. Thank you very much.
Thank you very much, Honorable Minister for Government Communications, the Honorable Felix Ofozukwache. Ladies and gentlemen of the media and my fellow countrymen and women, as the Minister for Government Communications has indicated, I am here this afternoon to speak to the sovereign people of Ghana on the position of the government of His Excellency John Dramani Mahama on the final recommendations of the Constitution Review Committee. The recommendations of the CRC were carefully considered by Cabinet on 3 occasions, including the dedication of an entire weekend retreat presided over by His Excellency the President to deliberate on the recommendations of the committee. But as the Minister has indicated, before I delve into the substance of the recommendations and what government the position that government has taken, this morning the Court of Appeal issued a decision unanimously acquitting and discharging Sedinam Atienu Tamaklo, who was convicted of various offenses in absentia because, she was standing trial. And in the course of the trial, she sought permission to travel abroad for medical reasons and then remain in the United States for the rest of the trial. The trial court convicted her of the offenses charged, and then an appeal was filed by her lawyers in May 2024. I want this to be made abundantly clear that it was my predecessor who filed the appeal. However, coming into office, I reviewed what was filed, and I directed the Director of Public Prosecutions to file opposing the appeal, because we believe that the High Court judgment had merit. Now, with this judgment, I've also directed the Director of Public Prosecutions to file a notice of appeal and apply for stay of execution, meaning that if the stay is granted, the status quo will prevail until such a time that the Supreme Court has had time to review the appeal and then made a determination. So that is all that I can say for now. I have a soft copy of the judgment. I'm yet to peruse it and then come to a firm conclusion as to what will be our grounds of appeal. But I want to emphasize that I believe that the judgment of the High Court had merit, and that the United States District Court that extradited her to Ghana had a basis for making a determination that she was the proper subject for extradition. And that is all that I will say for now. Now to the main business of the day, which is the government position on the final recommendations of the Constitution Review Committee. Now you will recall that on January 19th, 2025, His Excellency John Dramani Mahama appointed an 8-member committee chaired by Professor H. Kwesi Prempeh to undertake a comprehensive review of the 1992 Constitution. The committee was inaugurated on January 30th, 2025, and thereafter went straight to work on the task that the President had assigned to it. Over the course of nearly 1 year, the committee did a number of things. First, it organized 10 thematic stakeholder engagements involving over 500 experts and practitioners in law and governance. It held engagements with identifiable groups reaching over 21,500 people. It consulted 11 eminent persons, including former President and, of course, the current President of the Republic, who were closely involved in constitutional developments in the country. And then lastly, it received and reviewed 785 written submissions from members of the public. On December 22nd, 2025, the committee presented a summary of its recommendations to the President of the Republic. Subsequently, on February 10th, 2026, the committee submitted its full report containing the final recommendations. Those recommendations are the subject of today's press conference or press briefing. The report is titled Transforming Ghana from Electoral Democracy to a Developmental Democracy. The report is very comprehensive, well-researched, and reflects the consultative approach adopted by the committee in accordance with its terms of reference. It contains 147 proposals for amendment of the Constitution and about 59 proposals which are entirely new provisions, bringing the total proposed amendments to 206. On behalf of the government of His Excellency John Dramani Mahama, I wish to thank Professor H. Kwesi Prempeh and the eminent members of his committee, as well as the secretariat of the committee, for the excellent work done for our dear country and its citizens. Their names will forever be etched with indelible ink in the annals of Ghanaian history. Ladies and gentlemen of the media, and my fellow countrymen and women, I wish to make it clear from the outset that this is not a government white paper. The reason is that the work of the committee was not, technically speaking, the work of a commission of inquiry pursuant to Chapter 23 of the Constitution of the Republic. If that were the case, government would have had a constitutional obligation to either publish the report of the Commission of Inquiry together with a white paper, or give reasons why it would not publish the report of the Commission or Committee of Inquiry. The position of government in respect of the recommendations of the committee is formulated in 3 ways. 1, either we are accepting, that is, government is accepting, or 2, it is accepting in principle subject to modification, or 3, it is rejecting outright the recommendation of the committee. Where government accepts the recommendation of the committee in principle, that is subject to modification, we provide reasons why we seek to modify the recommendations. Reasons are also accorded where government does not accept the recommendations of the committee. In formulating the position on the final recommendations of the committee, government examined each recommendation against the relevant provisions of the 1992 Constitution of the Republic of Ghana to assess the nature, scope, and implications of the proposed amendment. Each recommendation was then subjected to rigorous constitutional and legal analysis, including whether it touched on entrenched or non-entrenched provisions of the Constitution, and whether its underlying objective could be achieved through other legislative or administrative means. We also examined the recommendations in light of the work of prior constitutional reform commissions or committees, such as the report of the 2010 Constitution Review Commission, in order to ensure continuity and consistency in the reform process. As I've noted earlier, when I submitted a draft position paper to Cabinet, extensive deliberations were held and each recommendation was interrogated weighed against the practical experiences of our country, and refined before Cabinet granted approval to this position paper. I have underscored the importance of this process in order to highlight the fact that the position paper being published today is not the product of one ministry or one department of government or a group of technocrats sitting somewhere in a corner and working at it. On the contrary, it is the product of the considered thoughts of the men and women who have been given the honor by His Excellency the President to run the affairs of our country within the executive arm of government. Before I turn to the highlights of the recommendations accepted or not accepted by government, indulge me a little to explain the principles that guided the formulation of the government position paper on the final report of the committee. First, government took the view that the Constitution is the supreme law and that any attempt to amend it should be done carefully. Therefore, recommendations that were considered insignificant in terms of their normative value were not accepted for constitutional amendment. The Constitution is the statement of our foundational values and structure, and not an operations manual designed to troubleshoot every problem in our society. Secondly, and this flows from the first consideration of principle, only changes that definitely required constitutional amendment were considered. Where the objective of a proposed amendment is best achieved through ordinary legislative or administrative means, a point that I have made earlier, government chose the alternative route. This approach was also animated by the fact that an ordinary statute can be amended by Parliament as circumstances change. It is not so with the Constitution of the Republic. My fellow countrymen and women, permit me now to turn to the highlights of what the government thinks is doable and in the best interest of the nation. That is the accepted recommendations. The government has accepted a recommendation to extend the term of office of the President from 4 years to 5 years, with the term of Parliament extended to correspond with this. Our thinking is practical. Under the current 4-year cycle, the early months of every administration are consumed by transition matters, and the final year is largely consumed by elections. A 5-year term provides a more realistic time frame for the formulation, implementation, and assessment of government policy. Still on the presidency, the committee recommended that the minimum age of eligibility for election as president be reduced from 40 years, currently in the Constitution, to 30 years. The government has accepted this recommendation in principle, subject to one modification. The minimum age will be 35 years, not 30 years. And of course, the details of this will be fashioned out by the Constitutional Review Implementation Committee. The current threshold of 40 years excludes qualified citizens from seeking the highest office on the basis of an arbitrary age limit. 35 is consistent with a trend in modern democratic constitutions towards greater inclusivity of the youth, whilst ensuring that a candidate for the highest office has attained a measure of maturity and experience to handle that office. We have also accepted that the presidential election be held on a day in the first week of November, as the Electoral Commission may specify by constitutional instrument. A fixed period gives certainty to the electoral calendar. It allows the Commission, the parties, and observers to plan, and it ensures an adequate interval between the election and the inauguration of the incoming president on January 7th. On presidential election petitions, the government has accepted that a petition must be filed within 14 days of the declaration of results and determined by the Supreme Court within 30 days. In other words, the Constitution will be amended to specifically provide for these timelines when it comes to the electoral petitions to be filed. And there is going to be a constitutional obligation on the part of the Electoral Commission to disclose all relevant data to the court and to all the parties. We take the position that because the timely resolution of election disputes inures well to the stability of our democratic transitions and to the general political stability of our country and society. The government has also accepted the principle that the president should not enjoy tax exemptions by virtue of office alone. The president will pay taxes on his salary and allowances, as well as the applicable indirect taxes on goods and services. The government has not, however, accepted the proposal to tax the president's retirement gratuity and pension, and the details of the president's tax liability will be worked out in the tax laws where such details belong. On Parliament, ladies and gentlemen, the government has accepted that the size of Parliament be capped. Before I go to Parliament, there is the issue of ministers of state and the number of ministers of state, which is one of the very, I would say, thorny issues that has bedeviled our democracy for some time now. Government has accepted the proposal to cap the number of ministers, but instead of 57, as the committee recommended, government is proposing that it should be capped at 60. So it will be put into the constitution that the number of ministers that any president elected by the sovereign people of this country can appoint will be only 60, and they may or may not be drawn from Parliament. Now to Parliament, the government has accepted that the size of Parliament be capped, and we propose a ceiling of 300 members. Now the current membership of Parliament is 276. So of these, the 276 will be elected directly in constituency elections like we already have. The remaining 24 will be elected or selected through proportional representation among women, persons with disabilities, and the youth. An independent study will be commissioned into the design of the proportional representation element. Capping Parliament saves costs, and the reserved element opens the door of our legislature wider to those our politics has historically kept on the outside. The government has also accepted a recommendation on dual citizenship. A citizen of Ghana by birth who holds the citizenship of another country will no longer be barred from contesting for election to Parliament only on account of his or her dual citizenship, and will not be required to renounce the other citizenship. The current disqualification sits uneasily with our engagement with the diaspora and with the realities of modern citizenship. In line with this proposal, it is also the case that multiple citizenship will no longer disqualify a person from becoming, from holding certain, offices, except that of a president and vice president of the republic. So the fact that you have multiple citizenship will not bar you from becoming Chief Justice of the Republic, or becoming the head of the Electoral Commission, or, for instance, becoming Speaker of Parliament. On to the judiciary. Regarding the judiciary, two positions deserve mention. First, the government supports a fixed tenure for the Chief Justice. That is a single, non-renewable term of 10 years, or until the age of retirement, whichever occurs first. And the age of retirement of justices of the Supreme Court now is 70 years. So if these amendments come into force and a person is appointed Chief Justice, that person will serve a 10-year non-renewable term. However, if the person's retirement comes first, the retirement will take place and the person will have to exit as a Chief Justice of the Republic. The second thing that I want us to note about the judiciary is that the government supports capping the Supreme Court's membership. Currently, the committee recommended a cap of 15 justices. The government proposes 19. That is the Chief Justice and 18 justices of the Supreme Court. Now, this cap promotes efficiency, manages public expenditure, while the bench of 19 remains sufficiently robust to discharge the court's constitutional mandate. On political parties, the committee recommended an amendment to Article 55 to require every registered political party to afford its members in good standing equal voting rights in the selection of its parliamentary and presidential candidates. The government has accepted this recommendation. just yesterday, as you recall, the Supreme Court, in the case of Professor Frimpong Boateng and others versus NPP, NDC and others, held that all registered members of political parties should be allowed to take part in their internal elections to select the presidential candidate as well as the parliamentary candidates. And therefore, on this question, the committee, government, and the Supreme Court now speak with one voice. Political parties are the vehicles through which we choose those who govern us. In fact, they are public entities, and they cannot themselves be governed just by a few. Relatedly, the committee recommended an independent body to register and regulate political parties in place of the Electoral Commission's current role. The government accepts this in principle. However, we prefer that the designation Political Parties Regulatory Commission be the nomenclature of, instead of a registrar and regulator of political parties. So we'll have political parties, a regulatory commission. The commission will be established through legislation, and matters such as the campaign financing and the proposed democracy fund will be addressed in that legislation, providing the flexibility a rapidly evolving field demands. On local government, on the election of district chief executives, the government has gone further than the committee. The committee recommended a phased approach under which the right to elect a DCE would be tied to a district's fiscal capacity, so that some districts would vote and others would not. The government takes the position that all district chief executives should be elected. Creating a distinction between voting and non-voting districts carries significant political costs and, of course, social costs as well, and may be perceived as discriminatory against citizens of non-voting districts. Under the government proposal, the president will nominate 5 persons, 2 of whom shall be women. Out of the 5, 3 shall be shortlisted, 1 of whom shall be a woman, after vetting by a committee drawn from the Ministry of Local Government, the Public Services Commission, and the Local Government Service. Those 3 will then be candidates for election as district chief executive or municipal or metropolitan chief executive. On the famous Article 71 office holders and matters of financial management. To deal with the question of emoluments of Article 71 office holders, the government has also accepted the establishment of an independent Public Emoluments Commission to determine salaries, allowances, facilities and privileges of public office holders listed in Article 71. Those include the President and other Article 71 office holders, such as members of Parliament, the heads of the Electoral Commission, NCC, the judiciary, etc. The current arrangement, under which a committee appointed by the President determines the emoluments of office holders, including the President himself, creates a structural conflict of interest and has been a persistent source of public dissatisfaction. An independent commission will bring transparency and equity to this matter once and for all. On the public financial management, the committee made far-reaching proposals. It made proposals relating to the classification and annual reporting of tax exemptions as tax expenditures, safeguards on the contingency fund, a medium-term economic framework laid before Parliament, debt anchors and fiscal sustainability rules, an independent fiscal council, and so on. The government shares the concerns underlying every one of these proposals. Our position, however, is that they belong in the Public Financial Management Act and not in the Constitution. Fiscal rules must be adaptable as economic conditions change. The Constitution should state principles. The statute should carry the procedures. The government will accordingly bring amendments to the Public Financial Management Act to give effect to the recommendations of the committee. On fundamental human rights, the government has accepted the recommendations to abolish the death penalty. Now, that is already underway in Parliament with the Honorable member for Medina, the Honorable Francis Xavier Sosu, leading the charge. So it's not new, but the committee made a recommendation on it. The relevant provisions of Article 3, 13, 19, and 72 will be amended accordingly, and offenses that previously attracted a death penalty will attract life imprisonment. The death penalty is inconsistent with the constitutional right to life and with Ghana's international human rights obligations under the UN conventions to which we are parties. Now, let me spend a moment on what I consider, in my opinion, as a key pillar of the position paper. That is what I call the proposed Human Rights Act. The committee made numerous proposals to expand the rights protected under Chapter 5 of our Constitution, including economic, social, and cultural rights, the rights of women, children, persons with disabilities, older persons, and the youth, the right to health care, the right to housing, the right to a clean and healthy environment, the right to food in custody, and many more. The government accepts the spirit of virtually all of these proposals. But here is the difficulty. Chapter 5 is entrenched, and every amendment to it requires a national referendum. Subjecting each of these new rights to a referendum would impose a procedural burden disproportionate to the gain from amending the Constitution in Chapter 5. The Constitution itself, ladies and gentlemen, shows us the way out. Article 33(5) of the Constitution provides that the rights expressly mentioned in Chapter 5 are not to be regarded as excluding others which are inherent in a democracy and intended to secure the freedom and dignity of man and woman. Pursuant to that provision, the government will enact a comprehensive Human Rights Act. The Act will elaborate on the rights already guaranteed, extend protection to the new categories of rights identified by the committee, incorporate Ghana's obligations under the international covenants I have mentioned, to which we are party, and provide detailed enforcement mechanisms, especially, resort to the High Court for redress where a human right violation has taken place. The Human Rights Act will be justiciable. It will improve standards as we evolve as a society, and then as our institutional capacities develop. Most of the committee's recommendations on fundamental rights are going into the Act. And ladies and gentlemen, the Constitutional Review Implementation Committee will have as one of its tasks to be assigned by the President the enactment of the Human Rights Act. Since the coming into force of the Constitution about 33 to 34 years ago, we have not added to the rights in Chapter 5. We have usually used Article 33(5), as I've indicated, as expanding the scope of rights, but without a statute that spells out the fundamental rights that we are entitled to. In the same spirit, the government has accepted a recommendation of a constitutional right of abode for persons of African descent in the diaspora, subject to conditions set by Parliament, with a heritage-based pathway to citizenship. Ghana has a proud tradition of welcoming the African diaspora, and this provides a principled framework for the year of return and beyond the return. Parliament will legislate the criteria and safeguards, and measures will be put in place to ensure that the right is not abused. Now, I need to underscore one thing. We have taken the decision that the Comprehensive Human Rights Act, when enacted, there will be a provision in the Constitution that will prevent the Act from being repealed willy-nilly by any government, except where the government secures 75% of members of the vote of members of Parliament to repeal it. On the issue of corruption and accountability, the committee recommended the establishment of an independent anti-corruption and ethics commission with the power to investigate and prosecute corruption, and to assume the functions of the office of the special prosecutor. The government accepts the proposal in principle, but the objective does not require a constitutional amendment. The government will, through the Conduct of Public Officers Bill, which is currently before Parliament, establish a public ethics commission with the power to investigate and, in some cases, prosecute acts of corruption and conflict of interest involving public office holders and their collaborators in the private sector. Its mandate would be similar to that of the Corrupt Practices Investigation Bureau of Singapore, but unlike that bureau, it will be independent of executive control. Ladies and gentlemen, this briefing would be incomplete without me telling you about the changes affecting my own ministry. It is not every day that a minister stands before the press to announce the splitting of his own ministry. The committee recommended removing the Attorney General's authority to prosecute corruption offenses and recommended requiring leave of the court before a prosecution will be discontinued. So, in other words, where the Attorney General wants to or wishes to file a nolle prosequi or terminate a prosecution, the commission was of the view, or is of the view, the committee is of the view that the Attorney General should provide reasons before doing so. Now, the government proposes that Article 88 be amended to remove the requirement that the Attorney General be a Minister of State. A separate portfolio of Minister of Justice will be established to oversee the justice sector, the justice and legal sector. The Attorney General will remain the principal legal advisor of the Republic and the repository of the prosecutorial authority of state, but will cease to be a Minister of State and a member of Cabinet. And to guarantee the prosecutorial independence of the office, a new clause will be inserted in Article 88 to give the Attorney General the same terms and conditions of service as a Justice of the Supreme Court. This is a significant restructuring of the legal architecture of the executive, and I believe history will judge it kindly. In other words, whoever is appointed Attorney General after the amendments come into effect, if you want to remove that person, you have to go through the procedure enumerated under Article 146 of the Constitution. There has to be a petition, the determination of a prima facie case, etc., etc. I know that members of the media are used to this process, having followed keenly what has transpired within our republic. On constitutional amendment and the roadmap, government has accepted the introduction of a citizen initiative mechanism for constitutional amendment. Citizens will be able to propose amendments to the Constitution upon securing the support of registered voters, subject to minimum regional representation and gender balance requirement. The government proposes that the threshold be 10% of registered voters, rather than the 5% recommended by the committee, so that the mechanism is invoked only where a proposal commands substantial national support. The initiative will be triggered through the Council of State. The Constitution belongs to the people, and the people should be able to knock on its door directly when they show wish. Now, the roadmap is set out in this position paper for amendments of the Constitution, set out in this position paper, and it is deliberate and time-bound. Following today's publication, the President will swear in the Constitution Review Implementation Committee. The CRIC, or CRIC, will prepare 2 Constitution amendment bills simultaneously. The first bill will cover the amendments to the non-entrenched provisions of the Constitution. It will follow the procedure in Article 291 of the Constitution. That is, publication in the Gazette, laying in Parliament, a referral to the Council of State for advice, and passage by 2/3 majority of all members of Parliament, followed by presidential assent. The second bill will cover the amendments to the entrenched provision. That bill must travel the road prescribed by Article 290 of the Constitution. It will be referred to the Council of State by Mr. Speaker for advice. It will be published in the Gazette for 6 months, laid in Parliament, and then submitted to the people of Ghana at a national referendum for approval. For a referendum to carry, at least 40% of eligible registered voters must turn out, and at least 75% of the voters must vote in favor of the Constitution Amendment Bill number 2 in respect of the entrenched provisions. The 2 draft bills should be ready by October 2026. And here, I should mention the practical reality. A national referendum is an expensive undertaking. To avoid the enormous cost of organizing a standalone referendum, the government intends that a referendum on the second bill, that is the Constitution Amendment number 2 bill, be held alongside the District Assembly elections in 2027, that is next year. We will work closely with the Electoral Commission and of course the Ministry of Local Government on the calendar for this to take place. Alongside the 2 bills to amend the Constitution as recommended by the committee, the government will bring the complementary legislative reforms I have spoken of, including amendments to existing laws such as the Public Financial Management Act, to give effect to the recommendations that do not require constitutional changes. In conclusion, ladies and gentlemen, countrymen and women, permit me to close with thanks. I thank His Excellency, the President, for his leadership in this process and for his unwavering commitment to constitutional reform. In fact, as I said, we had 3 rounds of meetings, including a weekend retreat. And His Excellency, the President, was present at each one of them and probably was the most alert person in the room. He gave leadership in terms of all the discussions on the recommendations. So I want to thank him for that, because he made some of the work that I have done very, very simple. Also, I want to thank my colleagues in Cabinet, including the Honorable Felix Ofosu-Kwakye, for their extensive input and helpful deliberations on the position paper. The document being published today is far richer for the scrutiny it received around the Cabinet table. And I thank once again the Review Committee and its eminent members and its Secretariat, whose diligent work made this moment possible. I wish to also put on record my sincere thanks to my able and indefatigable deputy, the Honorable Dr. Justice Srimsai. Justice held the fort in the course of law from the Supreme Court to the High Court, and on a daily basis, so I can devote time and effort to the constitutional reform project and to the management of the affairs of the Attorney General's Department. That is what I call true partnership at work and the kind of division of labor that produces results. I cannot also end without thanking the junior lawyers in our Secretariat, especially Lawyer Saeed Momin, for their tireless assistance in this project, and especially in the preparation of this position paper. The position paper and the final report of the committee will be published immediately after this press conference. Now, that is the headache of the Minister for Government Communications. I encourage every Ghanaian to read them. Constitutional reform is not a single event, but a continuing process. And the Constitution must remain a living document that responds to the needs and aspirations of each generation of Ghanaians. The next phase of that process begins today. Now, let me say this, that I have tried as much as possible to give you highlights. The government position paper itself is 89 pages, highly comprehensive, and some of the accepted recommendations have not been highlighted. So, as the media reports, please read the document very carefully. Don't go and take the highlights and say that government has rejected everything else. What we have done is to carefully examine, as I've said, the ones that are foundational, that go to the root of our constitutional democracy. And we have accepted those. We have also accepted those that we think the recommendations that should be accepted with modification. Some of the recommendations we are putting in Acts of Parliament, and so the committee's work will be reflected in both the Constitution as well as the legislation of this Republic. The committee has done a wonderful job for the people of this country, and again, I want to record my thanks. So, ladies and gentlemen, that is it for constitutional review. And as I said, the process starts today. Thank you. Honorable Felix. Before I said, let me do this. Sorry, thank you very much. I just wanted to show to our fellow countrymen and women the work of the Constitution Review Committee, the work of the H. Kwesi Prempeh Constitution Review Committee. Now, those who were in the media asking why government wasn't coming out quickly with the position of government, you should understand that this involved a lot of work. Personally, I had to read the entire document because I have to own everything that is said in the position paper. So I thank you.
Thank you very much, the Honorable Attorney General. So as he indicated, in the next few hours, we will publish both the full report of the Constitution Review Committee and then government's position paper so that you can make informed decisions. And we urge the public to read. There's a tendency for people in our country to ignore facts put before them and then say other things. Some will not read even a line in the document and yet would purport to analyze it. In order that we put all the matters into proper context, we encourage the public to read the documents as we put out. Then you can set it against the positions taken in the position paper and then make an informed judgment. So at this stage, we will invite questions from members of the press on the issues raised by the Attorney General at this briefing. Yeah. Yes, please walk up to the microphone and ask a question.
So mine has to do with the separation of the powers. We were told there was a suggestion that MPs cannot be ministers of state, and ministers of state can also not be MPs. I would want to find out why was a suggestion like this rejected.
All right, thank you.
Minister, thank you. My name is Obed Kingaglu. I work with EIB Network, GH1 TV and Star FM. I have two questions. One on the constitutional review proposals and also one on the case of Sedinam Tamaklo. So on the first one, on the constitutional review, I want clarity with regard to the change in date for presidential elections. Is it the same for the parliamentary?
Okay.
And then for the second one, you've indicated your intention to file a stay of prosecution and of course execution. I beg your pardon, and then of course appeal. Given the huge public interest of this matter, we want to find out the timelines when you are going to do this. Thank you very much.
Thank you very much.
Thank you very much. I'm Sethi, GBC. Honorable Minister, you made mention of government accepting the recommendation to cap members of parliament. I want to find out, after every population and housing census, the Ministry of Local Government comes out with the creation of metropolitan, municipal and district assemblies, and then the Electoral Commission goes ahead to also create more constituencies. But I didn't hear much about what is being done, the amendment that is being carried out to ensure that whenever there's a population and housing census, the Electoral Commission and the Ministry of Local Government will not go ahead and create more constituencies and more districts. Then there was also this issue about the committee recommending the abolishment of regional tribunals. Not long ago, the government took a bill to Parliament and successfully established regional tribunals. I'm sure President is here to assent to that bill. But then it didn't also find expression in the recommendations that the government accepts or rejects. Thank you very much.
Thank you very much. Yeah, Max.
Yes.
So maximize the time.
Yes. Maxwell Agbagba, Joy FM Journeys. My first question is on Sedinam. So you stated that the states opposed the appeal, but the Court of Appeal overturned that conviction. A lot of people are curious to know what kind of defense did the state put up. Was it strong enough to let that conviction, stand? And then also, what do you say to suggestions that the decision to appeal the Court of Appeal's decision today is a face-saving one? And then my last question on the Constitution. I want to find out, in a country seemingly polarized on partisan lines, I want to find out from the AG how he intends to build consensus to ensure that the Constitution review process, succeeds. Thank you.
All right, thank you. So we'll take the last one before the next round of questions. Yeah.
All right. Good afternoon. My name is Julius, and I write for the Ghanaian Times. I have two questions, and the first one has to do with dual citizenship. The minister mentioned that if successfully, the Constitution, if successfully amended, dual citizens will be allowed to hold public office, but for the president and vice president. So I'll relate this to the battle he is going through to have Mr. Ken Ofori-Atta extradited to Ghana. If we go ahead and then allow everybody to hold every public office, apart from the president and vice president, how sure are we that we don't put spies in office? So, for example, imagine if Mr. Ken Ofori-Atta was an American. How sure are we that even the Americans will even contemplate releasing him to us? That's the first question. So, what steps are in place to ensure that we don't have spies in office?
All right.
And then the second one, the CJ, the position of the CJ. Over time now, the removal of the CJ has become one topical one. So, for example, the CJ, the president, and then the Speaker of Parliament. But the removal of the CJ has become a bit easier, if you put it that way. To remove the Speaker, you need at least 3/4 of parliamentary votes to remove the Speaker. You need 2/3 of Parliament to impeach the President. But to remove the CJ, it's just a matter of the Council of States recommending that, okay, there's a prima facie case, go ahead, and then the President and whoever is involved, if they are convinced, after the committee recommends, the President must abide. What steps are we putting in place as a head of co-equal state arm of government? We don't just throw away the CJs, so that we have that balance in power. Thank you.
All right. Thank you very much. So the attorney now will answer these questions, after which we'll come back for further questions. Yeah.
Thank you very much for the very wonderful questions. On the question of separation of powers, which relates to whether or not we should appoint ministers from Parliament. Now, the current system under the Constitution is a uniquely Ghanaian constitutional arrangement that married the pure presidential system of government operated in the United States of America, for instance, and the parliamentary system of government operated in countries such as Australia and the United Kingdom, etc. And so the idea was that there should be ministers drawn from Parliament, so that the parliamentary experience, will be useful in terms of how government conducts its business or cabinet conducts its business. So it's a uniquely Ghanaian hybrid system of government, and we think that it has. I mean, there have been questions as to whether it has served us well. Okay, and we think that it is the provision that says, look, the president must, appoint more than 50% of his ministers from Parliament. That ties the hand of the president, meaning that the president, whether he likes it or not, will have to appoint ministers, from Parliament. But the current arrangement, as articulated in the government position paper, I'm sure you would see the details when you read it, is that we prefer that the president should be given a free hand. So when the president comes into office, he can decide whether or not he wants to appoint just one member of parliament as a minister, or he wants to appoint all his ministers from cabinet, which I think is not, no president will do that, because there will be expertise outside of parliament that the president will need. But it provides a certain level of flexibility, and it still preserves the uniquely Ghanaian hybrid system, of government. Now, there was a second question which I didn't get quite well. The person started talking about Sedinam Tamaklo, and I tried to motion to the person that, look, I have said it from the outset that this press conference is not about Sedinam Tamaklo. And also, as a lawyer of many years standing, I will not comment on a matter until I have read the judgment, and I have not read the judgment of the Court of Appeal. It has been sent to me, I have not read it. But I took the professional decision, and I stand by it in principle, that the appeal should be opposed. I inherited the docket, I inherited the extradition request, but government is a continuum. I reviewed the documents and I worked on them. So this is a principled stance, and it is a stance about accountability, okay, for this country. It's not about individuals. If it were about individuals, let me tell you, Sedinam is my friend. She's my personal friend. It's not about personalities. It's about this country. And I'll take the appeal on to the Supreme Court. And to tie it on to your the question about face saving, if you look at me, I'm not the type of person who fears losing face. All right, I am not doing this because I want to save face for either myself or the President of the Republic. I'm doing it based upon professional considerations, and also on the advice of the excellent men and women who work with me at the Attorney General's Department. So we'll review the judgment. You will see the grounds of appeal, and I'm sure at that point in time we can all have a discussion as to whether or not the appeal has any merit. There was an issue also raised about capping of the members of parliament, and then the question of population quotas. If you look at the Constitution carefully, in terms of the designation or the demarcation of constituencies, the Constitution provides that the population quota be used as a measure of the decision, as one of the benchmarks for a decision whether or not to create a constituency. Now, the population quota, as defined in the Constitution, is usually one of the benchmarks, but it is not the only benchmark. If you cap the number to 300, what it then means is that you cannot increase the number beyond 300, but you can redraw constituency boundaries and district boundaries in order to take account of the growing population, so that you don't have a situation where some members of parliament, or let me say some citizens, are overrepresented whilst others are underrepresented. Now, what do I mean? So if we were based upon the population quota alone, I should not be an MP, because Bolga is a very small constituency, and we have just under 35,000 when it comes to the voter population. Now compare that to Dominic, right? So whereas I'm serving just over 30,000 people, the MP for Dominic is serving over 100. The population there is very huge. All right. So left to the population quota alone, Bolga East should not exist. But the main point to be made for the decision of government to cap is that you cap it at 300, and if there is a need to redemarcate constituency boundaries, that will be done within the number that has been capped by the Constitution. Now, another person asked a question about the abolition of the tribunals. Well, if you read the government position paper, we have made clear what government's position is. The Constitution, as we have it now, establishes one integrated judiciary. The regional tribunals are currently part of the Constitution. If you read the Constitution, it is very clear. In fact, the district tribunals have been, the district tribunals are also justified pursuant to Article 126 of the Constitution, which provides that Parliament has the power to create such, lower courts and tribunals as it may determine. I know that the predominant argument has been that the tribunals of the past were not the best when it came to the protection of fundamental human rights. And I keep saying that the tribunals that will be established pursuant to the bill that is, that has been passed by Parliament cannot operate like the tribunals of the past. They will be regulated by procedures established by law. They will also have to take account of the fundamental rights and enshrined in the Constitution, as well as the procedural safeguards that either the Constitution or statute will prescribe. So, for instance, I do not see how a regional tribunal can decide to overlook Article 19 of the Constitution on fair trial and then hope that its decision will be upheld when appealed. So I believe that what we are doing is in tandem with the letter and spirit of the Constitution. There is textual support in the Constitution for the bill. And if I may say so, there is also spiritual support in the Constitution for the bill. So I am not going to yield to those who are saying that the bill is not in the interest of the people of Ghana. Because the tribunals do one thing that ordinary courts do not do. They allow for the participation of citizens in the delivery of justice. And the Constitution is very clear that justice emanates from the people and must be administered in their name by the judiciary. And the judiciary is defined to include the regional tribunals and such lower courts or tribunals as Parliament may by law establish. Go and look at Article 126 of the Constitution. I've answered the bit about saving face from the Sedinam matter. There is also a question about building consensus, given the fact that we are a very deeply divided and polarized country. Now, the level of polarization in this country is at, I agree, is very high. I also agree that it is at the level of the two main political parties. And so, in coming to this point of the constitutional review, I have tried my best to build bridges across the divide. I wrote to Parliament as a co-equal branch of government, and I submitted the report, the final report of the H. Kwesi Prempeh Committee to the Speaker. I also wrote to the Majority Leader, the Honorable Mahama Yarga, and gave him a copy. And I wrote to the Minority Leader, the Honorable Afeyo Markins, and gave him a copy. I reached out to the minority and requested that they give me a name to serve on the Constitution Review Implementation Committee. And I was given the name of the Honorable Member for Asante Achim, I think Central. That is the Honorable Kwame Imedu. Is it Central or South? Central. Yes. So hopefully he will be there to represent the minority. And then also we have a member of the majority caucus being there, and we have an eminent justice of the Supreme Court who will be the chair of that committee. So I have started building the bridges. And let me tell you something. This constitutional reform project is a national project. All right? Under His Excellency Nana Addo Dankwa Akufo-Addo, there was a constitution review committee which was spearheaded by the then majority leader, the Honorable Che Mensa Bonsu. I sat through the proceedings of that committee. I made my views known. I was then in the minority. I was a member of the minority, the opposition. But I sat through and I made my views known. So my hope is that being a national project and with the good intentions exhibited by His Excellency the President, will all come around the table, because the amendments that are being proposed are supposed to enhance, or let me say designed to enhance our governance. And if you look at the Constitution is very clear that governmental power must be exercised in the name of and for the welfare, underline the word welfare, of the people of this country. That includes, members of the minority. And I'm hoping that they will come around the table for us to all think through what is doable, what is practical, and what will inure to the welfare of the people of this country. Also, there's a question about Ken Ofori-Atta and the dual citizenship, and whether we will not be appointing spies into office. Well, to be honest with you, and I'm being very, very candid, all right, I have not thought about the question of spies in office. I trust that any of our citizens who has the citizenship of another country and wishes to offer public service will do so in good faith, all right, and with fidelity to the laws of this country. And it is not only dual citizens who can be spies. Citizens, people who do not have dual citizenship, can, because of material and financial considerations, turn themselves into spies for other countries or agencies of those countries. In our history, the CIA didn't pay dual citizens to overthrow Osajifo Dr. Kwame Nkrumah. If the people who did so, who betrayed him, had dual citizenship, I do not know. But I can tell you that the fact that a person has dual citizenship does not diminish their loyalty to this country. And so for me, I will stand by it. It's something that is long overdue, and we should be doing it. Now, should we be saying that, I don't know what the link is with Ken Ofori-Atta. I've never had any doubts as to whether he was spying for the CIA or any entity, and that is not my concern at all. It's not my concern. And given the situation in which we find ourselves, I would want to stay away from commenting exhaustively on the issue of Ken Ofori-Atta. There is also the question about the removal of the CJ. I think it's a legitimate question. Article 146 is not that simple. It provides a regime for removing the CJ on stated misconduct. It does not say that the president can, by the stroke of a pen, fire the CJ. It doesn't. It prescribes a procedure for determining whether or not the stated misconduct has taken place. But of course, there have been concerns raised about what has transpired recently, and I have noted those concerns and will be, as I said, refining the rules and elaborating on them to make it probably not that more difficult, okay, but just to ensure that there are no doubts raised when it comes to the removal procedures, or the removal of a Chief Justice. But you are very right that the judiciary is a co-equal, a branch of government, that the Chief Justice is an officer of state who should not be removed very easily. Okay? I do agree with that underlying principle. But was the current, the Chief Justice, the former Chief Justice removed easily? It was not. Thank you.
Thank you very much. So, no, nobody who has asked a question is coming back. We need to save time. So, the three of you who have not asked any question can ask any.
Okay.
Max, you had the opportunity. In the next 10 minutes.
Good afternoon, sir. I'll make it this very quick. The first one is on the referendum. You propose that you do it alongside the district assemblies elections, which is somewhere next year. But we would need 40% turnout for this referendum to succeed. The district assemblies elections are notoriously having low turnouts. The last one was 37%. The one before that was 35%. Are you not shooting yourself in the foot by putting this all-important amendment that you say you support alongside the district assembly elections, which normally will have a low turnout? If that turnout repeats itself, it means that your referendum will fail. How are you doing that? Don't you think it would be good to do a stand-alone referendum, even though it will be expensive, so that we know that we are succeeding? I would like you to clarify that.
Thank you very much.
I have just one question again.
Make it snappy, please.
On dual citizenship, it's not only Mr. Knufriata who is away. I don't want to bring that issue back. But Mr. Akoli is a dual citizen. And I've not heard us even ask questions about him, because we know that it is totally impossible. We won't get him.
How do you arrive at such a conclusion?
Because even Mr. Ofriata, who is our own, a Ghanaian citizen, we're having issues. I read that a court in America said there is no basis, despite all that we have done. So imagine their own citizen. What's the principle that MPs, Attorney General, who will now have the tenure of a Supreme Court judge, can have an American citizenship and a Ghanaian citizenship, but a vice president and a president cannot have? What's the principle? What's the difference?
All right, thank you.
My name is Kwame Asante. I work with Onia TV, Onia FM. My question is simple. With the proposed month of November that the Honorable Attorney General said they are proposing that we should have the general election, the election of the president, and then that of the members of parliament in November. Is there a proposed fixed date in November that election will be held? We know December, it was December 7.
I thought the AG answered that, but anyway, he will take the opportunity to reiterate it here.
Good afternoon. My name is Romeo Tete, and I report for Ahoto FM. Honorable AG, please, we want to know the number of recommendations made, especially on media reforms. How many of those were accepted and how many were rejected, and if any reasons. And please, lastly, for the avoidance of doubts, when is the new changes of the president's term in office starting? Is it starting from the current president or the one that comes after him? Thank you.
The AG was very clear that it does not apply to the current president. Thank you very much. Okay, Max.
Thank you very much. This last question is in the spirit of oral. Yeah. No, so I just want to find out from you, Honorable AG, you've made known your intention to appeal this decision. I know that in the spirit of double jeopardy, if it fails at the Supreme Court, we cannot continue. Would you be willing to bring fresh charges against Sedinam if the appeal fails? Would you be willing to bring fresh charges? Thank you.
Yeah. Okay. Thank you very much for a second round of excellent questions. As I indicated earlier, I would employ all of you to read the government position paper thoroughly as media people, because it's very, very comprehensive. Now, on the referendum, the concern that you have raised about the 40% threshold is a real concern. But and again, from the statistics that you have put out, the district assembly elections usually attract very low turnout. Okay, so if we were to just tie it to the assembly elections and rest it there, then you can be sure that we may not be able to get the 40% threshold prescribed by the Constitution. But the referendum is a key aspect of the legacy of His Excellency John Dramani Mahama. And therefore, there will have to be, educational activities by bodies such as NCCE regarding the referendum. Of course, I'm sure civil society groups will take part in whipping up support for the referendum, given the fact that it is supposed to, it is designed to ensure that we put through these constitutional, amendments that are designed to ensure that our country is very well governed. So the threat is real, all right, but I don't think that it is a threat that we cannot overcome. So a standalone referendum for now is not what we are proposing. We'll work with the EC and then the Ministry of Local Government and Chieftaincy and Religious Affairs to see what date will be fixed, and then we can take it from there. Now, there was a question about Mr. Akoli. All right. I think of the two, because Ken Ofori-Atta was a Minister of State, our former Finance Minister, there's always focus on him. But the request that has been sent by my office includes that of Mr. Akoli. And now, take it from me. All right. The fact that a person is an American citizen does not immunize them from extradition. All right. So, American citizens can be extradited to Ghana. All right. Well, the fact that it has never happened doesn't mean that it cannot happen. But I'm telling you that from a legal technical point of view, the position that you have taken is wrong. The fact that somebody is a dual citizen doesn't make it difficult, doesn't, put a roadblock on the way to extradition. Even if that person is not also a citizen of Ghana, they can be extradited to Ghana to stand trial. All right. Then there was a question about why the distinction between offices. I think that the discussion excluded the high offices of President and Vice President of the Republic. All right. I believe that if somebody wants to rule this country, okay, they should be in a position to say that, look, I do not want to be the citizen of another country. And I think that that is probably the basis why those two positions, in fact, even all the civil society groups that have campaigned on this, there is a bill to amend the Constitution that is currently being considered by the Parliamentary Committee on Constitutional and Legal Affairs. And in that bill, people like Professor H. Kwesi Prempeh, as well as Professor Kogu Asari, have agreed that the two high offices of state, that is President and Vice President, should be left out. But I want to also let people know that historically, for instance, we had Justice Apalo, who was a chief justice of this country, okay, leaving Ghana and becoming Chief Justice of Kenya. He was a Ghanaian citizen, but he was appointed Chief Justice of Kenya. Okay, so these are matters that I think the CRIC will look at. They will be debated in Parliament, subjected to a referendum, and eventually will come to a position as to whether or not we want to go forward with them. Then the question about proposed fixed date in November. I said we will consult with the Electoral Commission to be able to determine what that date should be. So we don't have that, and the government position paper did not specify a date for the elections. There are a lot of recommendations on the media. Of course, you cannot have the Honorable Felix Ofosu-Kwakye around the cabinet table and not expect that recommendations regarding the media are included in the position of government. And so there are recommendations, for instance, on the National Media, Commission and its, role in the regulation of the media in our country. Those recommendations are contained copiously in the report. Then also, the last question that touches upon the government position paper is on the term of the president. All right, I made it clear that this is forward-looking. Okay, it's forward-looking. We have proposed that the 5-year term be the term of the president when the president is, elected. All right. Now, if we look at it critically, and the term of parliament has also been, we have stated quite clearly that the term of parliament should also be enhanced to, 5 years. All right. The question whether it should apply now or should apply, in the future, and whether, for instance, Parliament can decide that in passing the legislation that its life be extended by another year. Those are all matters that will be hammered out when the CRIC begins its work and Parliament begins the process of enactment. Will I bring fresh charges? That is legally impossible. After the Supreme Court speaks, I don't see how I can bring charges. Fresh charges. Yes, unless the evidence is different. Unless, yes, if I get fresh evidence, okay, of wrongdoing, that will be an entirely different kettle of fish. From saying that based upon the same charges, I'm going to arrest her after the Supreme Court has made a determination. Either way, let's say the Supreme Court says that the High Court was wrong, or it affirms the Court of Appeal. I cannot legally, I'll be legally barred. Okay? But as I said, I don't want to comment on the substance of the appeal. We will publish the arguments of my office that were filed before the Court of Appeal. And again, subsequently, when we file our appeal in the Supreme Court, there will be public documents. And for those of you, the media houses that have lawyers, I'm sure they will read them and determine whether I am right or I am wrong. But I have taken a principled stance, and that stance will go forward. I thank you for your attention and for the wonderful questions. Thank you.
So thank you very much, Honorable Attorney General, and thank you all for coming.